This is Bloomberg Law with June Grasso from Bloomberg Radio.
Johnson & Johnson first filed for bankruptcy in North Carolina, then in New Jersey. Will the third time in Texas be the charm? J&J is trying to resolve tens of thousands of suits alleging its talc-based baby powder caused cancer by using special bankruptcy rules that allow corporations facing financial turmoil to force an end to all product liability lawsuits. The Third Circuit Court of Appeals in Philadelphia nixed its first bankruptcy attempt, and a New Jersey court nixed its second. Now it will be up to a judge in Texas, if the case remains there. Lawyers representing talc claimants who oppose J&J's latest settlement proposal are asking Texas bankruptcy judge Christopher Lopez to transfer the case to New Jersey. J&J says it has overwhelming support for the roughly $8 billion settlement because 83% of alleged victims voted for the deal. Joining me is Anthony Casey, a business and corporate bankruptcy professor at the University of Chicago Law School. Tony, tell us about the history of J&J's bankruptcy attempts and about the Texas two-step.
So this goes back to 2021. Johnson & Johnson, their consumer subsidiary, had been the defendant in suits alleging ovarian cancer and mesothelioma being caused by mostly their baby products line, although there's some other products involved, containing talc. And so there was a bad judgment around that time, and this leads to the decision in 2021 to file an entity into bankruptcy, and this is when people start talking about the Texas two-step. Now, the allegation is that there's asbestos in the product, and so what they looked to was a precedent where a few other companies had filed what had become pejoratively known as Texas two-steps. The idea of the Texas two-step is, step one, you divide the defendant entity into two entities, one that houses the kind of ongoing business and one that houses the liabilities. Step two, you put the liability company into bankruptcy. And this, if you describe it that way, a lot of people get worked up and say, oh, look, that's a fraudulent transfer. Everyone kind of skips over. There's an intermediate step, which is you also include a funding agreement. And the funding agreement says when the entity goes into bankruptcy, the new liability company, the new asset company guarantees to make available the value of the assets that were available before the division. And by doing that, you're saying, look, we're actually making all the money available to the claimants for whatever liability ends up at the end of the day, but we are separating the entities so that the bankruptcy only involves those liabilities. And the idea behind this is to streamline the bankruptcy. Now, as I said, this kind of pejoratively became known as the Texas two-step. Where does that come from? Well, the statute under which you divide the company in the first step is the Texas divisional merger statute. And there have been a few companies who had done this previously where they divided under the Texas statute. Then they did step two. They filed in North Carolina, a Western District of North Carolina, and those are still pending, those cases. So Johnson & Johnson, really Johnson & Johnson Consumer Products, those Consumer Inc., JJCI was called, that company does the divisional merger, creates the new JJCI and the LTL. LTL files in the Western District of North Carolina. There's a funding agreement that says all of the assets that were available before the division are still available. The value of those are available and guaranteed for whatever liabilities end up. And in case those assets lose value, the parent company, J&J, guarantees to make good on any change in value. That was bankruptcy number one. Now, that very quickly gets transferred from the Western District of North Carolina to the District of New Jersey. There's a motion to dismiss in that case. The bankruptcy court denies the motion to dismiss, says this is a good use of bankruptcy. Bankruptcy is a tool to solve collective action problems. You've got tens of thousands of claims against this debtor. There's more coming in the future. The only way to get a global settlement is through a bankruptcy process. This is what bankruptcy is intended for. That goes on appeal to the Third Circuit. The Third Circuit says, no, you should have dismissed the case. Nothing to do with the Texas two-step other than the funding agreement provided value And the Third Circuit says there's too much money available here for you to claim that you need to be in bankruptcy. You're too solvent. You're not in immediate financial distress. There's an irony in that is they said it was a bad faith filing or not in good faith filing because the debtor provided too much value for the creditors, which is normally the opposite of what you think of when you think of like what's a bad faith debtor doing. They protected the setup so that there was enough money to cover the claims, and the division didn't change the amount of assets available. Because of that, the Third Circuit said you're not close enough to financial distress. So that was attempt one. So that case gets dismissed. A couple hours after the dismissal becomes effective, you have attempt two.
So J&J filed the second time in New Jersey, which is the jurisdiction of the Third Circuit.
So what they do, following kind of the logic of the opinion from that Third Circuit opinion, is they reduce the amount of money available, but they maintain enough so that we're still a solvent entity, so that we're not going to underpay creditors, is the way that they, the second debtor, framed it. And they file bankruptcy again, and this time in the District of New Jersey. This time, the bankruptcy judge says, well, I'm looking at the opinion before, I'm looking at what you did. There's still enough money available that you're not close enough to financial distress, as I understand the opinion from the Third Circuit, so I'm going to have to dismiss this case. That goes on appeal to the Third Circuit. The Third Circuit says that's right, affirms, and essentially reiterating its opinion in the first case and saying that the bankruptcy court had applied it correctly in the second case. All right, so now we're on round three. So in the third round, Johnson & Johnson's announced, I think back in May, earlier in the summer, rather than file bankruptcy and then see what happens, we're going to get the vote first. We're going to go out to all the claimants and try to build a settlement. Now, the goal of the first two bankruptcies was to be in bankruptcy and then build a settlement that creates a fund that allows claimants, both past and future, to come and collect against that fund and the company to continue operating separate from the fund. This time around, they're like, well, let's get everyone on board on the fund first. So they do what's called a prepackaged bankruptcy. So we're going to get a vote of all the potential claimants, and we've got to get a supermajority to get a settlement through. That was true in the first two cases, but we hadn't had the vote yet. This time, we're going to do the vote. We're not stopping any of the litigation while we're having the vote because we're not going to file unless we get to the point where we have the vote in place. Now, during that time, they apparently determined that they were going to use bankruptcy to settle the ovarian cancer talc claims, but not the mesothelioma claims. So they separate those off. And they have a vote among the ovarian cancer claimants over the summer. And then at the end of that, they now say they have roughly 83% of the potential claimants voting for a settlement. And the settlement was kind of laid out here. If you vote for this, here's the plan we're going to put before the bankruptcy court. We'll have a vote when we go in. Are you on board with this? Because if you are, this is prepackaged in the sense of we know who's voted. You're the only class of claimants because of the simplification and splitting off. So what they did then was another divisional merger where they separated the company into three entities. So there was the holding company that existed. That company kind of swallows up all of the other entities that had been divided out and then divided into three: the going forward company, the mesothelioma company, which is going to settle outside of bankruptcy, and the company that's going to file for bankruptcy, which is the talc claimants. And that's the case that filed last Friday, right? So this is the new entity filing, and they file in Texas this time with the vote in place, the plan drafted in line, hoping to get the kind of approval through the Texas bankruptcy court.
So the opponents of this, some of the lawyers representing claimants, say that J&J is trying to game the system because it's trying to get bankruptcy protections that are meant for companies that can't afford to pay their debts. Do you agree with that?
No. So this has been the debate from the beginning with the question of whether or not bankruptcy is the right place for mass tort claims to be resolved, whether or not the Texas two-step is a positive or a negative. Now, one thing to note is that bankruptcy in the U.S., Chapter 11, I should say, corporate bankruptcy, has always been a tool for resolving collective action problems among creditors where their actions could destroy value. And the way that they can destroy value is you ultimately get a race to the courthouse. And so if you think about any of these mass tort cases, you've got tens of thousands of claimants. Some of them are going to go and get a zero recovery. Some of them are going to get $1 billion recovery. And there was one large judgment for a group of plaintiffs that was in the billions. And what happens is that we don't know when these claims, particularly with asbestos, will end because asbestos shows up years later. And so you have a decades-long future of litigation that's costing, at one point I think they said it was costing $1 billion a year to litigate these cases, and that's destroying value. Now, the Third Circuit in its first opinion said, look, you're Johnson & Johnson. There's enough money for this to go on for quite some time without it causing any problems. Now, that's true. If these claims are actually valid, that won't always be true, right? If you have 100,000 claims that are worth millions of dollars each, that'll bankrupt any company in the world. Now, the irony was people say, well, yeah, but they're not really valid claims, so they're not in that much financial trouble, which is a weird argument. I mean, everyone's arguing these from odd positions. The plaintiffs are arguing, yeah, but most of the claims aren't any good, so you don't need to worry about it, which is such an odd argument. And what's really going on is stakeholders are losing value in the current world because there's this just endless litigation. If money runs out, it'll be the case that the first to come win and the later to come lose. And bankruptcy has the only mechanism in our legal system that can get parties to a global resolution that says, here's the money available. Let's stop destroying value. And that benefits the debtor, but it also benefits the creditors because it gets the money put aside and available sooner rather than later. So if you're in line, if you're one of the current 80,000 claimants or so, when is your trial going to happen? When is your settlement going to happen outside of bankruptcy? And if you're someone who doesn't even know that they're sick yet, the timing of when the value gets put aside for you is years or decades away. So bankruptcy, the way I look at it, is intended to solve those kind of problems, right? It says, look, when you have a pool of assets and you have a group of creditors who collectively want the same thing, but individually have incentives to kind of try to cut in line, get ahead of each other, and get the big payouts, we want to solve that problem. That's what bankruptcy is supposed to do. The critics, as you say, go, no, it's only supposed to be when you're running out of money. And if you look around the world, there are jurisdictions that have said, you can't file for bankruptcy until you're totally insolvent. And what you see is that companies fail because they don't file soon enough. And there's been a trend around the world of things called pre-insolvency proceedings, which are countries realizing that, wait, it's too late if we start helping them when they're insolvent. We should do what the U.S. does and help them before they're insolvent, but we can't do it because our system requires them to be insolvent. So let's create a whole other system, a pre-insolvency system. If you look at Chapter 11, it's both. It says you can file early, you can file before you're insolvent, you can file when you're insolvent. We want to encourage you to use it as soon as you become aware of the potential to preserve value through coordination. Now, it is true, if there was a debtor that had zero possibility of ever having financial problems, bankruptcy is not made for that debtor. And that was what the first bankruptcy opinion in New Jersey said. It said, listen, if you do the math, there's a possibility here, a real one, that this is going to eat up a lot of value for people. Now, the Third Circuit says it's not immediate enough. They didn't define that, but they said it has to be, somehow imminent or on the horizon. And my view, and I think the view of a lot of lawyers and some bankruptcy scholars, is that just makes people wait too long, and it engenders litigation of, am I close enough? Am I close enough? And you get weird cases where American Airlines and Hertz, for example, everyone thought they were insolvent when they filed for bankruptcy, but at the end of their bankruptcies, they were solvent. Does that mean that you need to undo everything because they shouldn't have been there? Right? You don't want to be litigating that every day, do you have enough money? Do you not have enough money? And that's why my view of the Third Circuit rule, which is the only court that has that immediate financial distress rule, is too onerous on debtors and discourages filing. The colorful metaphor people use is it tells them to call the fire department after the house burned down, right? You want to do it earlier. You want to do it when there's some potential danger or value destruction that you're trying to stop.
Coming up next, will the judge transfer the case to New Jersey? You're listening to Bloomberg. Johnson & Johnson's third bankruptcy filing to resolve tens of thousands of lawsuits alleging its talc-based baby powder caused cancer is facing familiar challenges by opposing lawyers, including its new choice of venue, Texas. I've been talking to Anthony Casey, a business and corporate bankruptcy professor at the University of Chicago Law School. So why did J&J pick Houston for the third bankruptcy filing?
I don't know why exactly it picked Houston. There's a couple things going on. One is, when they filed in North Carolina, the court said, well, you created this entity in Texas, and the next day you filed in North Carolina, so we're going to venue transfer you to New Jersey. So to do this structure where you simplify and say, look, we're only putting into bankruptcy the claimants whose claims we're trying to resolve, and the ones who overwhelmingly want to resolve it, right? They voted, they want to resolve this. In order to do that, you need to do this divisional merger, which requires you to be a Texas entity when you do it. So one reason they might have filed in Texas, they're like, look, we're not going to venue shop this time. Everyone criticized us for it. So we'll do a Texas divisional merger, and then we'll file in Texas, right? So that's one argument for why to file in Texas. I don't think it's lost on people that if they had filed again in New Jersey, right, they would have faced the same standard. And so New Jersey, because of the Third Circuit rule, puts in place a block that says you can't restructure this until it's too late. And so I think those two things together made Texas the obvious venue to file, right? So the Third Circuit, which would be Pennsylvania, New Jersey, and Delaware, right, that's off the table because you'd have to make the company so close to insolvency, dangerously so, that you might be taking something away from the claimants, right? This entity is just money and a settlement for the victims. And so if the requirement in the Third Circuit is you need to make that entity insolvent, the requirement is you need to make sure you're not paying the claimants in full, right? So you don't want to do that, and if you go that far, you run into a fraudulent transfer problem. So you really, if you want to resolve this, you can't file in the Third Circuit. Now, no other circuit in the country has that rule, so that opens up the possibility of other places. And again, like when they filed in North Carolina the first time, they got venue transferred, but filing in Texas, well, you're Texas entities. You have to be Texas entities because that's what was required for you to do this structure. So, inferring here, okay, well, we'll just file in Texas, which also is a very experienced, known jurisdiction that's dealt with a lot of large cases. So you're not going to overload the court in that way, which some people thought maybe that was happening in North Carolina. So those would be, I think, the reasons they're in Texas. But that's why I don't think there's any venue transfer coming.
And that was my next question, because the attorneys for the talc claimants who oppose the latest settlement proposal are trying to get it transferred out of Texas. And the Justice Department's bankruptcy monitor, the U.S. Trustee's Office, had filed in New Jersey to get it transferred to that state.
And that already failed, right? So the New Jersey motion, I didn't quite understand why you're trying to file it there. There's lots of legal problems with trying to get the New Jersey court to take the case from Texas. Partly, there is a bankruptcy rule that says if a debtor with a pending case files somewhere else, the court with the pending petition can bring it in. But the New Jersey court dismissed the case, right? There's no petition pending there. So it's not clear that that court would even have the power. There's all kinds of weird questions that arise if the New Jersey court tries to take it. So one, it's not clear the court could take it, but two, the court has the discretion not to, and I can't imagine would want to open up all those questions, which I think is why it already denied that motion yesterday afternoon, saying, for now I'm not taking the case. I think it said without prejudice, and they might try it again. Okay, so then the right place to bring a venue transfer motion is in the court where the case that you want transferred is pending. Like, that's what the statute says. That would be the Texas court. But what's the argument for transferring it? So the argument for the New Jersey court to take it, generally that rule in bankruptcy is, in order to make administration easier and more coherent, we should bring the cases together. The New Jersey case has been dismissed, so there's nothing to administratively bring it together with. So there's not that argument. So then, if someone really egregiously manufactures venue, courts can transfer venue. Now, this would be the court where you filed, to the Texas court. But go back to, well, why is there venue in Texas? Well, it's a Texas entity. Why is it a Texas entity? Because the only way to structure the thing this way was to make it a Texas entity. And so Texas actually is the first and obvious place to file for a company that has used the Texas statute to structure itself in this way where we simplify the bankruptcy. And to think about it, the simplification, the mesothelioma claimants aren't voting for a bankruptcy settlement. The ovarian claimants are. And so the value of the separation, just to use an example, is we're going to put the ovarian claimants into the bankruptcy process, which overwhelmingly they voted in favor of, and we're not going to put the mesothelioma claimants. We're also not going to put all the other creditors of the operations of the business. We're not going to have them subject to the bankruptcy, and we're not going to have them able to step in and make objections. So we're really simplifying it so that the only way that a plan gets confirmed in the Texas bankruptcy is if there is a valid vote of a supermajority of these claimants. No one else can affect that. It's really just about whether or not they want this settlement. And that's the simplification that the Texas two-step allows. And if to get there you have to become a Texas entity, that makes Texas, in my mind, the obvious venue. Now, some people are going to say, some critics are going to say, but you should never have been able to do the divisional merger in the first place. The only problem with that argument is no court has ever said that. And importantly, the Third Circuit, when they dismissed the case, it was not because of the structure. It was because too much money was available. That was the only reason. And if you read it, the opinion applies to any debtor who isn't close enough to financial distress, regardless of how they're structured. And so as I read the opinion, it would have applied to old JJCI, the old Johnson & Johnson Consumer Company. Had it filed without ever dividing, the Third Circuit rationale suggests it would have dismissed that case. It has nothing to do with the Texas divisional merger. And so at that point, you're like, well, state law says you can do this. They did this under state law, and now they're Texas entities. The first time, they then moved to North Carolina and got a venue transfer. So this time they didn't do that. They stuck with Texas, and they filed in Texas. I don't see what the argument to the court is for venue transfer. Where should this case be? It should be where the parent company is. I guess that would be the argument for sending it back to New Jersey. But as long as we're allowing the divisional merger, it's not clear why that has any benefit to anybody, right? It doesn't make the case smoother. It doesn't make the case easier. There's nothing to consolidate it with. So the only reason I would see to transfer it is if you went as far as saying you can't do the Texas divisional merger, which would be a shocking thing for a federal bankruptcy court to say that a state law transaction is just out of bounds.
So then you think that there's almost no way that the Houston judge will transfer venue to New Jersey?
Correct. Yeah. I didn't think there was any chance the New Jersey judge would take it, and we saw that, and I think there's no way that that'll change. And I think there's very little chance that the Texas judge will send it somewhere else, because I just don't see if you look at the statute, read the language of the statute. Where's your principal place business? Where's your headquarters? Where are you incorporated? Those are the things you look for, and here we have that. We have a business that is a Texas entity, and so this isn't a mailbox case. This isn't anything, and it wasn't on the eve either, right? So these transactions were announced months ago, right, and voted on by the majority of creditors and claimants. So all the formal things are there, and then if you get to discretion, what's the discretionary reason to send the case somewhere else when you've got a supermajority of the claimants in favor of it, when you've got the venue, the move to Texas was very open. The reasons for it are very clear. I'm just trying to think, what's the hook for sending this case somewhere else?
I can see that the lawyers for the cancer victims who want to try their cases, why they want it moved. But why does the Justice Department want it moved?
So I think the trustee's office has taken a negative view of a lot of the mass tort bankruptcy structures. Maybe they're of the view that, like you said, that you need to truly be insolvent. This is partly why they appealed to the Supreme Court in the Purdue case. They had a policy view that you're not supposed to use third-party releases in master bankruptcy cases. I'm a little surprised in their motion in New Jersey because the office tends to be kind of textualist and formalist, and if you look at the rule, I don't see how the New Jersey court had the power. And so they were asking it to do something, I think, that would be not formalist, beyond the power of the statute, which is not the way I normally think of their positions. That said, I think that they view themselves as the watchdog of bankruptcy process, which I think is a good thing, but they have a view that what large companies are doing to reach mass tort settlements in bankruptcy is problematic. I think that's an incorrect view, but I think that's what's driving this. As you say, it's not, their views are put out there even when they conflict with the majority views of the claimants. And that was true in Purdue for sure, and it seems to be true here as well. They're just like, but this is the way it should be done, and that's why they want it, I guess, in New Jersey. I mean, the weird thing about wanting it in New Jersey, if you're a claimant, why is New Jersey any different? So the claimants are everywhere. So it's not clear like why New Jersey is better for a claimant than anywhere else. Now, maybe their view is you've already been dismissed in New Jersey. You should stay there. You shouldn't be able to try to change things. And that view, if you go down the road, gets really problematic because how long would you be bound by? The company's circumstances change over time. So how long do they think they're bound by the fact that they had a ruling in one court at one time and then, a year later, a company files again, even after it was dismissed? Like, are they bound into infinity to never file anywhere ever again? It can't be right. So I'm not totally sure the theory that the trustee's office has, but it seems to be that they don't like what's going on in a kind of a vague sense.
And there'll be basically nothing going on until October 11th. Judge Lopez ruled that no talc litigation can proceed against J&J until that date, while he considers whether the bankruptcy case should proceed in the Houston court or not. So he could find out fairly quickly whether the bankruptcy will proceed in Texas or not. Thanks so much for being on the show, Tony. That's Professor Anthony Casey of the University of Chicago Law School. Coming up next on the Bloomberg Law Show, with AI supercharging the threat of election disinformation, California's governor has signed 3 bills to crack down on the use of AI to create false images or videos in political ads ahead of November. I'm June Grasso, and you're listening to Bloomberg. With artificial intelligence supercharging the threat of election disinformation, lawmakers across the country have raced to address the issue over concerns the manipulated materials could erode the public's trust in what they see and hear. California has been on the cutting edge of regulating AI, and Governor Gavin Newsom signed 3 bills last week to crack down on the use of artificial intelligence to create false images or videos in political ads ahead of the election. Joining me is Joanna Rosen Forster, a partner at Crowell. So, Joanna, start by telling us about the rising concerns about AI and deepfakes in particular.
Yeah, I think that there has been a rise at the state and at the federal level of concern with respect to what we're calling deep fakes, which is passing off somebody's image or voice as authentic, even though it's been manipulated or is artificial, and using AI or not even using AI, just using Photoshop to do it. And the concern being that on one hand, is it deceptive to consumers? Is it deceptive to voters? Are their votes being manipulated or procured through false means or pretenses, and to a degree also with respect to actors and personalities and celebrities, their likeness? I think the big issue that we all are thinking about on this is the Taylor Swift deep fake that was a few weeks ago. So I think there's been a big concern about the use of AI to manipulate images in elections in particular because of the concern that it could falsely procure votes or put undue influence on voters. And the concern has also risen with respect to AI tools because the AI tools make it so easy to make the deep fakes and to make the deep fakes so convincing such that it's almost imperceptible to the naked eye or indiscernible to humans that it is indeed a deep fake. So, Congress has been considering this for a while. Congress, for better or for worse, has been unable really to put together any type of real, true federal statute or federal mandate on this. leaving it to the states to start to regulate on this. I think when I last looked at it, over 40 states have now, in some stage of legislation, whether it be introduced to enacted or are addressing this. And last week, Governor Newsom in California passed into law a set of landmark, what's being called first in the nation type laws that really address not only celebrity likeness and control for celebrities in deep fake, which is with respect to elections or not, just in general, carte blanche, the use of a personality's image or likeness in a deep fake. And then separately, a series of bills that were passed in California, he signed into law that specifically addressed the threat of using manipulated or artificial images and sound recordings in elections. And it's been hailed as an effort to really try to safeguard the election process, make it safer, more secure, and be more fair and equitable. And those laws went into effect immediately. So they are in effect right now. I think the concern that you see from industry in a lot of ways is that one of the laws, AB 2655, is directed almost entirely at social media companies and puts a lot of obligation and burden on the shoulders of social media companies operating in California to identify, root out, address, take down deep fakes or things that they think might be deep fakes. And it's caused quite a scramble for social media companies as a result.
How would these laws be enforced?
Yeah, it's a great question. So there's 3 different sets of laws with respect to the electoral process. So 2 out of the 3 can be enforced by average citizens, can be enforced by the elected officials themselves, or by the attorney general. And what they do is they create a private cause of action and or the ability for the attorney general or for a state enforcer to file an action in court that takes precedence. So they get to the top of the docket for injunctive relief or other remedies. So there's not really much of a financial stick. In California, we have the Fair Political Practices Commission, and for decades now, it has had the power to enforce violations in the electoral process for pecuniary violations, right, for $5,000 per violation. These other laws really more give power to individuals, to the elected official itself or the candidate, and to enforcers of the law in California to bring civil actions and to seek injunctive relief.
Without these kinds of laws, how difficult is it to get social media companies to take down content when someone says that's a deep fake?
Yeah, so that's, I think, the real question. And I think you're going to get different answers depending on who you're talking to. And I think if you talk to legislators in Sacramento, the reason why they passed 2655 was because their argument is it's almost impossible to do it. I think if you were to talk to social media companies or talk to those within the ambit of the definition of social media, which in California could also embrace potentially certain e-commerce companies and others, it was really defined to be companies that have outward-facing websites or applications to consumers or end users and have at least 1 million users in California in the preceding 12 months. So we're not talking only about YouTube and Google and X. It's a much broader sweep. So I think that if you talk to the social media companies, they would say, we're doing this already with respect to the tools that we have and with the powers that we have and the contractual obligations that we have under our terms and conditions. And that's really, I think, the crux of the issue is that the legislators are saying, you're not doing enough. The social media companies are saying, we're doing what we can when it violates our terms and conditions, our rules of play to being on our platform. And I think they would also say, frankly, there's a limit to what we actually have to do, that this legislation abrogates our rights under the First Amendment. It is potentially preempted by the Communications Decency Act, Section 230. So I think there's conflict there about what social media companies actually have to do and whether statute can require them to do it also.
And did the social media companies lobby against the bill?
They did. If you look at the legislative history and the letters that were submitted, you see a fair number of letters that were submitted by institutions like the First Amendment Coalition, which was arguing exactly what I said, that these laws abrogate social media companies' First Amendment rights and are preempted by Section 230. You had NetChoice, which is a trade group that represents many social media companies and internet players. They also lobbied and wrote letters in protest to the law. In the amendment process, some of their concerns were addressed a little bit, and then an urgency measure that was also adopted and enacted with 2655, which is AB 2839, addressed some of the social media companies' concerns, but the root issue here, the first principle here that the social media companies are concerned about is, hey, this is government intrusion. And the Supreme Court, in what those of us who work in the space consider landmark, on July 1st, issued a case called Moody versus NetChoice. And in that decision, a majority of the justices said that Texas and Florida laws essentially requiring social media companies to curate or not curate political speech implicated the First Amendment. And you had that majority ruling, and then you had concurring justices essentially saying that social media companies and the way they present information to end users and their selection, the feed, are expressive compilations which are worthy of First Amendment protection. So you have this tension now between what legislators think might be right for people and what first principles of our country are with respect to First Amendment.
Now, there's a battle over SB 1047, which is California's first of its kind AI safety bill. And there's a question about whether Governor Newsom will even sign it. He has until September 30th to do that. Why is that bill so much more controversial than the ones he did sign?
The bills that were passed were really more focused on the electoral process. And the AI bill is not just potentially, but is far more wide-sweeping and would create disclosures or requirements with respect to the use of AI in nearly everything and every aspect of a California citizen's residence experience with AI. The three bills that were passed last week solely deal with the electoral process. So something to note about AB 2655 is it really is also time constrained. So this burden on social media companies and in general labeling or disclosing deepfakes or otherwise taking them down, for the most part, it's in relation to an election. So it's 120 days before the election is when the obligation kicks in, and runs in some instances, depending on the section of the statute, runs for 60 days after the election. So in an election year, when you've got a primary and a general, it may be in place, for most of the year, but outside of the electoral process, it has no effect.
So someone has to sue to enforce these laws to get a deep fake in a political advertisement taken down, let's say. The election is in, less than 6 weeks? So how fast can that be done in California's courts?
Yeah, so all three of the laws create precedents for these lawsuits. And in 2655, the one that regulates social media companies, the cause of action can arise very quickly. So the general process is that the social media companies have to have some type of mechanism or repository or interface on their sites now, or some type of email address where a consumer, an end user, a citizen, even a candidate or a committee could say, hey, this image of candidate X is a deep fake, you need to take it down. And the social media companies have 36 hours. It's not very long, a day and a half to reply back and say, we've taken it down, or here's what we're going to do. In some instances, they have 72 hours, but that cause of action arises very quickly from the time that they are on notice. And then once that time period elapses, ostensibly the cause of action is complete if the action hasn't been taken or no action has been taken, and the claimant can run into court, and their case pursuant to the statute gets priority. So they go to the front of the line. And so what I would envision, because it affords injunctive relief, is that you would see litigants filing for TROs or preliminary injunctions, which also get heard and ruled on a fast-track basis.
Thanks so much, Joanna. That's Joanna Rosen Forster, a partner at Crowell. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.